Hi, and welcome to Fridays with Vistage. I'm Lori Allen. Just a reminder, you will receive the slides from today, as well as other great resources about midweek next week. Our topic for today, how a well-structured asset protection plan will protect you and your business. Our presenter is Hillel. He's an MBA, author, attorney, and president of the Presser Law Firm. He's been featured in major publications, and he's written 3 books you can see on your screen. Here's something you will love about Hillel. Like you, he's a Vistage member, but he's also a Vistage speaker. So if you like what you hear today, please tell your chair because Hillel would be happy to speak to your group. Hillel, tell us about protecting our assets.
Thank you so much, and thanks so much for having me today. So today we're going to talk about So Sue Me. We're going to teach everybody how do you protect both your personal and your business assets from the lawsuit explosion. Next slide, please. Next slide. Next slide. Next slide. We'll talk today about a little bit of background information about asset protection. We'll talk about some asset protection techniques and tactics. And we'll also talk about some real-life examples and Q&A. So certainly we'll save some time at the end for Q&A. You know, I always get asked why I became an asset protection attorney. And as far back as I can remember, if you would have asked me when I was 10 years old what I was going to be, I would have told you hands down that I was going to be an attorney. And it probably had something to do with the fact I grew up in upstate New York, Rochester, and I was very close at that time with my Uncle Jimmy. Uncle Jimmy was a personal injury attorney, and Uncle Jimmy was one of the first personal injury attorneys to ever advertise on TV. And every time I had a summer break or vacation, I'd go work at Jimmy's office. I'd answer phones, I'd stuff envelopes, I'd help sign up clients, anything and everything I could do to help learn the practice of law. And if you asked me back then what type of attorney I was going to be, I probably would have said a personal injury attorney because that's what I knew. Now, I knew Jimmy as Uncle Jimmy, but the rest of the world knew Jimmy as Jim the Hammer Shapiro. And he used to get on TV and scream at the top of his lungs, Jim the Hammer Shapiro. I'll wring out every penny, squeeze out every dime. You don't have to like me. Just make sure you call me. I may be an SOB, but I'm your SOB. And I want to take a minute now to go ahead and just show you one of Jimmy's ads.
Victims, 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 victims. I'm proud to say that many victims call me their last resort. I accept injury cases that most lawyers won't take. I want to get you all the cash you deserve. I'm Jim the Hammer Shapiro. 1-800-546-7777. 1-800-546-7777.
I only showed you one of Jimmy's ads, only because we are short on time. I'll resist of showing you my favorite ad where his face actually pops out of the 0, the 1-800 number. But I think you get this point. And I didn't show you Jimmy's ad because I'm proud of Jimmy. I show it to you because this was 30 years ago. Today, this is the norm. Every bus bench, who can I sue? Every TV ad and radio ad, who can I sue? Every bus, every billboard, who can I sue? How can we take the money out of the hard-working business owners and redistribute the wealth, and of course have the attorneys take about 40% in between? So it's so great to be one of the very few attorneys in the entire country that helps people protect what they've worked so hard to obtain. So what is asset protection? You know, there's many definitions of asset protection, but the definition that I give is that asset protection is the legal process of titling both your personal and business assets to put them beyond the reach of future potential threats and creditors. And what we do as asset protection attorneys is we help our clients protect any asset they have from any financial threat. So the assets might be as simple as checking, savings, stocks, bonds, brokerage accounts, primary homes or rental or investment real estate, Maybe shares in a corporation or membership interest in an LLC. We see that a lot with the business owners because their biggest asset is their business. But it might even be intellectual property like domains, trademarks, phone numbers, and we're protecting them against any financial threat. So obviously in today's day and age, the majority of that is lawsuits, car accidents, slip and falls. But it might be litigation at work from partners, suppliers, employees, customers, anything that can take what you worked your whole life to obtain away from you. And a lot of people say, well, do I truly have enough assets to protect? Isn't asset protection only for the wealthy? And the short answer is that every single person needs some sort of asset protection plan. I always like to give the examples. We represent a lot of professional athletes, NFL and NBA players, and take one of my NFL stars who signs a contract for $50 million. Well, if he's sued for $5 million, he's not going to be happy, but he still has $45 million left. Contrast that with the everyday person who's worked their entire life very hard, maybe to only save up a couple $100,000 for retirement. If they're sued for $1 million, it's going to be catastrophic. There's absolutely no coming back from that. And a lot of people say, well, what if I already have an asset protection plan? And if you do, that's great, but you definitely want to have it checked on. Every 1 to 2 years, laws change in the asset protection field, and you want to make sure that your plan is current. Also, we're going to talk in detail later today about trusts, but probably one of the biggest misconceptions I see in my office is that somebody will walk in, they'll have a trust, and they think that their assets are protected. And I never understand if the attorneys aren't giving the right advice or maybe the clients aren't understanding it correctly, but the majority of trusts will not give you any asset protection. Trusts do a great job from an estate planning point of view, but nothing from an asset protection point of view. And, what is the difference between estate planning and asset protection? Estate planning deals with death. When you pass away, where do you want your assets to go? Certainly you want them to go there quickly, privately, and with the least amount of taxes that's legally and ethically possible. Asset protection deals with how do you protect what you have while you're alive? Because if you don't protect it while you're alive, you'll have nothing to pass on. Now, you'll see that I go through some of these slides rather quickly, and that's because I did a previous webinar with Vistage, and I don't want to repeat any of the information that I did. So if you see me go through a slide quickly, please feel free to check my other webinar that I did with Vistage, which is more of an overall overview and basic understanding of asset protection. People say, why do I need asset protection? And I always like to show this cute cartoon. It's two lawyers talking. One says, I say sue. The other one says, anyone in particular. And unfortunately, this is the truth. Just like we're all smart enough to get together on Fridays and learn from one another on these webinars, the lawyers are getting together. But they're not getting together once a week or once a month. They're getting together every day. And they're trying to figure out who's going to be our next target. Is it going to be the financial advisors for lost investments, the car manufacturers for faulty products, the business owners? Who can we sue next? Who's going to be our next target? There's over 100 million lawsuits every single year, and that number is only growing. Lawsuits have truly become the next biggest business. There's an attorney probably on every single corner that will take a case for free on contingency fee, which means you pay absolutely nothing, but it's going to cost you tons of money to defend yourself. So unfortunately, they make it so easy and inexpensive, if not free, to sue somebody, but so difficult and expensive to protect yourself. There's a 1 in 4 chance you will be sued in the next 12 months, and the average person and business is sued 5 times over their lifetime. So if you have an LLC or an S-Corp, on average you're sued 5 times. On average, the company's sued 5 times. Now, understand these are just nationwide stats. I'm not trying to scare you. These are just the nationwide averages. There's a 50% chance of divorce. When I give this speech in South Florida, I say there's a 99.9% chance of divorce. And a lawsuit can cost you tens of thousands of dollars even if you win the case. Somebody can sue you. It doesn't cost them a penny. You can defend yourself for 3, 4, 5 years and win. But if you've spent $50,000 or $100,000 in legal fees, is it really a win? So the trick is not making money, it's keeping it. And the challenge that I give to all the Vistage members are for every 60 minutes you spend making money, spend 60 seconds thinking about how to protect it. Well, a lot of people say, what about insurance? Isn't that what insurance is for? And I am a big proponent of insurance. I tell my clients to buy as much insurance as they can because it's cheap and it helps you sleep at night. But understand that insurance are for-profit companies and that 70% of insurance claims are not covered. Think about it. Insurance companies are for-profit companies. They want to take in as much as possible and pay out as little as possible. That's why when you drive down the highway, the insurance companies are the ones that have their names on all the big buildings. Your coverage may be inadequate. What if you have $300,000 of coverage for your car, you hit someone and they have $1 million in medical bills? Who do you think has to come out of pocket for the other $700,000? You. Your insurance company might go bankrupt. Now, if I would have said this 10 years ago, you would have kicked me out of the room. Today we have banks and Fortune 500 companies going out of business. Who's to say that the insurance companies won't go next? And also, insurance doesn't cover other uninsured financial risks or divorce. And it's actually funny. I was Googling online, and now there's actually a company that offers divorce insurance. You pay a monthly fee, and if you get a divorce, they pay you. Who knows what will be next? My point, guys, is insurance alone is not the answer. You need your own asset protection plan to supplement your insurance. I like to call it the belt and suspenders approach. You want to make it so difficult, so expensive, if not impossible, for anybody to come after you that they don't want to sue you in the first place. And if they do sue you, you want to be able to settle for a much lower amount. So how will a well-structured asset protection plan help you? Number one, discourage lawsuits. You want to sell your plan and sell your protection. I can't tell you how many times an attorney will threaten to sue one of my clients. We will go to the back of the office, pull the file, copy it, and send it to the attorney. We'll tell him everything our client has, where it is, just that he can't get to it. If you can convince the other side that you or your client is uncollectible, nobody wants to sue them. You know, lawyers are lazy. They want to do the least amount of work for the most amount of money. If they sue you and it takes 3, 4, 5 years and they win $2 million judgment against you, if you're uncollectible, if you're not the low-hanging fruit, there's no point of suing you in the first place. So you want to sell your plan and sell your protection. You also want to negotiate inexpensive settlements. You know, an asset protection plan doesn't mean you'll never write a check. You have to be reasonable. An asset protection plan means you'll write a far smaller check. So we've had cases before where maybe a client had a $5 million judgment against them. You know, the creditors went after him for years and years and never got a penny. But the client doesn't want to have that judgment over his head for his entire life. So maybe you settle the case for $500,000. You know, you still write a check, but if you can pay 5, 10, 15, 20 cents on the dollar, we've done our job correctly. You want to protect your assets from judgments. You want to reduce your insurance costs. And you want to keep your wealth safe from other financial threats. Most importantly, you want to help achieve your other financial objectives. And I just want to take a minute and touch on this because when I present to Vistage groups all over the country, this is the biggest problem I see. We have all these successful business owners in the room, and they have all these talented advisors. The problem is that none of these advisors are talking. In order to be efficient for you as the client, you need to make sure that your financial advisors are talking. That means that your asset protection attorney must be talking to your estate planning attorney. Your estate planning attorney must be talking to your CPA. Your CPA must be talking to your financial advisor, et cetera, et cetera. And the reason being is that people can't be alone on an island. You know, what good is it if somebody makes you a lot of money, your financial advisor, if you're paying more in taxes? You know, what good is it if you're paying less in taxes if you lose everything to a lawsuit? So you really want to make sure that you have a financial self-defense team, you appoint somebody as the financial self-defense quarterback, and you have to make sure that your financial advisors are talking. I like to do it, you know, once a month, once a quarter, but start off with once a year. I promise you, you know, the money you'll pay for that one phone call and the hour of your time and their time, you can save tens of thousands, hundreds of thousands, if not millions, by all being on the same page. So, 8 keys to a good asset protection plan. Number 1, protect every asset. First thing I make a client do when they come into my office is inventory what they have, because everybody always has a lot more than they think they have. For example, people only think about the liquid assets of the real estate, but maybe somebody owes you money. Maybe you're going to get an inheritance. Maybe you have a domain or a trademark or a phone number that's valuable. So you need to make sure that you protect every single asset. Example I give is a guy came in, he was being sued, and he said he already had an asset protection plan, but could I review it? I said, sure. I looked at it and I said to him, your lease is not protected. And the guy looked at me like I was crazy. He said, my lease is a $5,000 a month liability. That's not an asset. He was actually incorrect. The lease that he had was a very old lease that was very long term. The going market monthly rate was roughly $20,000. The creditors actually took his lease and sold it at auction for $250,000. So you need to make sure that you inventory everything that you have and that you protect every asset. You also need to make sure that everything's 100% legal. We have a nationwide law practice. We handle clients nationwide, and we do both domestic asset protection inside the United States and international asset protection outside of the United States. There's nothing wrong with having offshore bank accounts or international companies. There's something very wrong with having them and not filling out the proper reporting requirements. So whether you're doing domestic or international, you always need to make sure that you're filling out all the proper reporting requirements with the state, the IRS, the Treasury Department, etc. You want to keep it simple and cost-effective. I've authored a number of books on asset protection, and oftentimes people will buy them online, and they'll call me and they'll say, I need a personal international asset protection Swiss hybrid trust, and I want that trust to own an entity international asset protection LLC. Slow down. Start very simple. Start very cost-effective. As your personal assets grow, your plan can grow. As your business assets grow, your plan can grow. As your education grows, your plan can grow. You always want to make sure that it fits your other financial goals, exactly why we want your whole financial self-defense team talking. You want to keep all of the control. So the whole key with asset protection is to own nothing but to control everything. You always want to keep it up to date. Hopefully every year you get an annual physical. Every year you should be getting a financial physical. You have to be comfortable with your plan. The whole point of your asset protection plan is so you can go to bed at night knowing, God forbid, if something happens and you're sued the next day, that nobody can take what you worked so hard to obtain. Maybe your assets warrant an international asset protection plan, but if you're not comfortable with it, you shouldn't do it. And also, it must be totally effective against any threat. We talked about protecting every asset, but it shouldn't matter who's suing you, your next-door neighbor or the most powerful attorney in New York City. Your asset protection plan should be able to stand up the test of time. So there's a lot of different strategies with asset protection, and I'm just going to go over the four main strategies. In the middle, we have exposed wealth, and that's anything that's in your personal name. If you have anything in your personal name, it's exposed. So I want you just to take a minute and think about what is in your personal name. Do you have real estate in your name? Checking accounts in your name? Stock, bonds, brokerage accounts in your name? Shares in corporations or membership interests in an LLC in your name? If you do, all of those assets are exposed. If it's in your personal name, you can lose everything. I don't want to have anything in my personal name. Again, the key here is to own nothing, control everything. If it's in your personal name and somebody sues you, they can take it. So the first thing I try and get my clients to do is stop worrying about ownership. You really don't own anything. You might think you own your primary house, but really it's just a long-term lease. You can't take it with you when you die. So what do? Anything in your name is exposed. Anything exposed you can lose. So you want to have absolutely nothing in your personal name. One strategy is to transfer the asset to a protective entity. So there's lots of different types of protective entities, LLCs, limited partnerships, trusts, et cetera, et cetera. And it's a pretty cool thing. Just like you and I are different people with different Social Security numbers, if you get sued, they can't come after me. If I get sued, they can't come after you. Well, no difference between you and your protective entity. You have a Social Security number, and your protective entity has a tax ID number. So if you have a $500,000 brokerage account in your name, you could lose every penny. If you take the same $500,000 brokerage account and put it in a protective entity, maybe a limited partnership, which we'll talk about today, nobody can take a penny. No difference with real estate. Instead of having a rental or investment property in your name where somebody can take it, put it in a protective entity like an LLC where no one can touch it. Another strategy is to protect with liens. I always tell people that poverty is power. you want to look poor because that means nobody will want to sue you. You know, what's a $100,000 Mercedes worth if you owe $95,000? What's a $1 million house worth if you owe $950,000? You want to use liens and mortgages and UCCs and encumbrances on your property. So, for example, if you loan a couple $100,000 to your business for employees or marketing or whatever the expense might be, why not file a UCC, a lien, a mortgage against the company? That way, if God forbid the company fails, you're the first creditor in line. You know, I have a client who likes to buy an expensive Ferrari every year. Well, obviously he has no money in his personal name because that would be exposed, which means he can lose it all. All of his money is in his protective entities. So he takes the money from the protective entity and he buys the Ferrari. Then the protective entity puts a lien on the Ferrari. So now he's driving around a fully paid off Ferrari, but there's a lien on it. So God forbid if anyone sues him, they can't take the car. And that's dealing with combining different strategies. We've combined both the protective entity strategy with the lien strategy. You can also convert into exempt assets. Every single state has different exemptions. And if you go to our website, it's www.assetprotectionattorneys.com. There's a tab on the left-hand side called Financial Exemption Planning. If you click that, you'll see every single state, and then go ahead and scroll down and click on your state. It'll tell you every single thing that's protected in your state. Your house might be protected. Your retirement accounts might be protected. Your life insurance might be protected. Your annuities might be protected. Every single state is different, but why not put your money in assets that happen to be protected by state law? And lastly, transfer all ownership rights. And this deals with owning nothing and controlling everything. If you have shares in a corporation in your name, you can lose them. If you have membership interests in an LLC in your name, you can lose it. So you want to get everything out of your name where it's exposed and either put it in a protective entity, protect it with liens, convert it into an exempt asset, or transfer all ownership rights. I want to touch briefly on the C Corp versus the S Corp, both different types of corporations. The C Corp has double taxation. That means that when the C Corp makes money, the company pays taxes on the profit. However, when the shareholders, the owners of the C Corp, take money out, they also pay taxes on the money. So with a C Corp, you get taxed twice. That's why most people don't like a C Corp from a tax point of view. With that being said, I really like it from an asset protection point of view. And the reason being is that the C Corp can be owned by anyone or any entity. So you can own shares in a C Corp, you can have an LLC own shares in a C Corp, a trust own shares in a C Corp, a limited partnership own shares in a C Corp. So it's very easy to protect the shares in the C Corp. The S Corp, on the other hand, has lower taxes. You know, when the company makes money, the company does not pay taxes. What happens is the profit passes through to the owners of the S Corp, and the owners of the S Corp pay taxes. So instead of double taxation where both the company and the owners of the shares pay taxes, with an S Corp, only the owners of the shares pay the taxes. And most people like this because it has lower taxes. It's also good for less than 75 shareholders. If you're going to have a public company, you're certainly going to use a C Corp. But the reason I do not like an S Corp from an asset protection point of view is it has a lot of limitations on who can own the shares. An S Corp must be owned by a U.S. individual, a disregarded entity, or a very special trust. And don't forget, if the S Corp shares are owned by a U.S. individual, that means if you get sued, you can lose everything. And I just want to give you an example because it's the biggest misconception I see. People walk into my office all the time with S Corps, and it's probably the worst structure you can have, and here's why. Why does anybody set up a corporation? Anybody sets up a corporation because they want to protect their personal assets from business liability. If they set up a hat store in their personal name and somebody sues them, they can be sued personally for everything they own. If they set up a hat store in a corporation's name, well, if the hat store gets sued, the creditors can only go after the assets of the corporation and not after the assets of the personal owner. With this being said, and presumably all my fellow Vistage member business owners, your biggest asset is your business. So what happens if you're sued having nothing to do with the business? Well, if I sue you for a car accident or a slip and fall, for $100,000 and you have $100,000 in the bank, I could take the $100,000. I can freeze your account. If you don't have the $100,000 in the bank, but you have $100,000 in Facebook or Apple or Google stock, I could take the $100,000 in stock. There's no difference between the two assets. One's $100,000 in cash, one's $100,000 in Facebook and Google and Apple stock. Well, no difference if you own shares in an S Corp or a C Corp. If you own shares in an S Corp or a C Corp and I sue you, I can take the shares that you own in that S Corp or the C Corp. Now, if I have the majority, I can vote, which means I can hire, fire, liquidate the bank account, bankrupt the company, etc. I've seen companies that have been around for many, many years go out of business, not because the company did anything wrong, but because the owner of the shares of the S Corp or the C Corp were sued. The creditors took the shares and took over the entire business. So really important, corporations are great to protect yourself against business debts. They can protect your personal assets from business liability, but they're terrible to protect your personal assets, a.k.a. the shares in the corporation. So if you're currently operating out of an S Corp or a C Corp, you definitely want to look into it just to make sure that you're all buttoned up. So moving on to trusts and gifts. First, let's just talk about the trust basics. In any trust, you have a couple different parties. The first party is the settlor or the grantor, and they are the person that starts the trust. So if you've ever started a trust, you were the settlor or the grantor. There then is a trustee, and the trustee is presumably someone that you trust, whether it's a husband, a wife, a child, an attorney, a corporate trustee like a bank, but it's someone that you trust that watches over all the assets that you put in the trust. They actually own legal title to these assets. And they're watching over them on behalf of the beneficiaries. And the beneficiaries are just whoever you set the trust up for. So your wife might be a beneficiary, your husband might be a beneficiary, your kids might be a beneficiary, family members, friends, maybe even charities. So the main party is the settlor or the grantor, the person who starts the trust, the trustee who watches over the trust, and of course the beneficiaries are the ones who are going to benefit from the trust. Now, there's two main types of trusts. The first type of trust is called a revocable trust. Some people call it a living trust. Others call it a domestic revocable living trust. And the key thing to understand is that with that type of trust, with a domestic revocable living trust, when you put an asset in the trust, you can take it out at any time. And when people walk into my office, 99 out of 100 people who walk into my office who currently have a trust, this is the type of trust they have, a domestic revocable living trust. If you're not sure what type of trust you have, I can almost guarantee that this is the type of trust you have. Anytime you put an asset in the trust, you can take it out because it's revocable. This is the biggest misconception I see. Those trusts offer 0% asset protection. And think about it. If you can put an asset in the trust and take it out when you want, well, if you have an asset in the trust and you get sued, the judge can make you take it out. So these domestic revocable living trusts give you absolutely no asset protection. Now, with that being said, they do offer really great estate planning benefits, so I believe everyone should have them, but understand that you're not getting any asset protection benefit whatsoever. The other type of trust is an irrevocable trust. The irrevocable trust means that when you put an asset in the trust, you can never take the trust out. And most people don't want to do that because they're not at a point in their life where they want to irrevocably give up both control and ownership. Now, if there's a client who has $20 million and they're in their mid to late 80s, they might not mind taking $5 million or $10 million to put in an irrevocable trust as long as they have enough to live on, but most younger people aren't willing to do that. So only an irrevocable trust can protect your assets. You cannot control the trust because, again, as we mentioned, with the irrevocable trust, you must give up both ownership and control. You always want to use spendthrift trusts to protect the heir's inheritance. So what that means is you want to have all different types of language in the trust. And understand, guys, that you can customize your trust agreement any way you want. So I hate when I see a trust that says, you know, a child gets something a third when they're 25, a third when they're 35, a third when they're 45, because those are what I call mandatory distributions. You know, what if at age 25 your son is being sued for a car accident? What if age 35 your daughter is going through a divorce? So I never like any mandatory distributions. So you might want to easily change that to say at 25 the trustee should consider giving a third. At 35 the trustee should consider giving a third. That way, God forbid the child or whoever the beneficiary is going through a lawsuit or some sort of litigation or financial threat, they don't have to give them the money where they would lose it. Also, you can use your trust to encourage things. Maybe you're big on education. Why not put clauses in the trust that say if your child graduates from a 4-year university, the trustee should consider giving them $100,000. If the child graduates with a 4.0, the trustee should consider giving them an additional $50,000. If the child graduates from a master's or doctorate or law program, the trustee should consider giving them another $100,000. So you can literally individualize and customize and tailor any way you want. I remember hearing about someone, he was very well off, and he put in his trust, whatever my son makes, I will match it. So if the son makes $100,000, the trust paid him $100,000. If the son made $1 million, the trust paid him $1 million. So it's not that I want you to rule from the grave, but you can really encourage and help protect your children from themselves. You always want to use an ILIT to own life insurance, and this is really important. So we're actually going to have an entire separate slide on it in a little bit. And your revocable living trust will not protect your assets. So just make sure that you understand that. Also, there are some very comprehensive trusts that you can look into from a tax planning point of view. Certainly I'm happy to speak to you about it, but today we're really focusing on the asset protection. So trusts and gifts, and I just wanted to touch briefly on the domestic asset protection trust because we're seeing it more and more often now. You know, essentially a domestic asset protection trust is a newer type of trust that's set up inside of the United States. It started off in about 5 to 8 states. Now it's in about maybe 13 to 15 different states. And essentially what it is it's a self-settled trust, which means you set up this trust where you're the settlor or the grantor, you're the one setting it up, but you're also the beneficiary. I would really, really, really stay away from these. I see these really being offered mostly not really by true asset protection attorneys, but more from estate planning attorneys, you know, who want to have another product or service to offer. And I've never set one up. I never will set one up, and that's for a few reasons. I hate domestic asset protection trusts. Number one is they're new. So I certainly don't want my clients being the test case for something that's new. Number two is that they're only offered in different states. So let's take an example. Let's say Alaska allows the domestic asset protection trust. Let's say the client's in Florida, and let's just pretend Florida does not allow it. And let's say the client has property in Florida and New York, and let's pretend New York doesn't allow it. So now you have a Florida client with property in Florida and New York. Both Florida and New York we're going to pretend do not allow this trust, and Alaska we're going to pretend does allow the trust. Well, what law takes precedent? You know, are the assets protected because everything was put in a Alaska trust, you know, that does allow the domestic asset protection trust? Or does the Florida or New York law take precedent and say this is not allowed? I think a judge would be within his right power and responsibility and legally and ethically say that the assets are not protected. Also, these domestic asset protection trusts are state laws. And everybody knows that federal law trumps state law. And there's a federal law called the Full Faith and Credit Clause. And what that says is that a judgment against you in one state is good in another state. So if I sue you in Florida and get a judgment against you, I don't have to sue you again in New York to get another judgment against you. The Full Faith and Credit Clause would make sure that I have a judgment in every state. So even if this domestic asset protection trust was set up in a jurisdiction or a state that allows them, and even if the client was a resident there and held all property there, I would try and remove the cause of action to federal court and argue that federal law trumps state law. So I am not a fan whatsoever about a domestic asset protection trust. I've never set one up. I never plan on setting one up, although you never know, things could change. But they're starting to become more and more popular, and really I think the clients are throwing out their money. I think they'd be better, you know, taking a vacation with their family. So really against it, and just thought it was worth, you know, touching base on. So moving right along to irrevocable life insurance trusts, or ILITs for short, and this is really, really important. Whenever I give a speech to Vistage members around the country, I say, who has life insurance? And everyone raises their hand. And out of every 15 or 20 people that raise their hand, when I ask who has life insurance in their personal name and who has life insurance in an ILIT, 99% of the people have life insurance in their personal name. Well, there's a huge tax savings if you do things correctly. Take a $5 million policy. If you have a $5 million life insurance policy and it's in your personal name, and you want to leave the $5 million to your son, well, when you pass away, because that $5 million life insurance policy is in your name, it's counted as part of your estate, which means depending what the estate tax rules are at the time, depending on what's going on with exemptions at the time, you're going to die with an extra $5 million because that's how much the life insurance policy was. So depending what estate taxes will be, they might be 50, 55%. Let's just use 50% as an easy number. Half of it, $2.5 million, goes to the IRS, the government, for taxation, for estate tax, and half of it goes to your son. Well, if you would have had the same $5 million policy and you put it in an ILIT, an irrevocable life insurance trust, now you do not own the policy. The life insurance policy is owned by your ILIT. Well, when you pass away, that same $5 million policy, the full $5 million goes to your son tax-free, both income tax and estate tax. So where the confusion is that, most people set up a life insurance policy and they think it's tax-free. But what they don't understand is that it's only income tax-free. It's not estate tax-free. So very, very important that when you have a life insurance policy that you put it in an ILIT because you could save millions and millions of dollars. Now, if you already have a policy and you want to switch it to an ILIT, no worries, you can. Certainly there's a bunch of paperwork that needs to be done. There's crummy letters, et cetera, et cetera. But the main thing is that there's a 3-year look back. So you need to make sure that you stay alive for 3 years. If you stay alive and you die after 3 years, there's absolutely no taxes. If you pass away within 3 years, you're still going to have to pay the estate tax. And what the rule is here to govern is that the government doesn't want you, at 101 on your deathbed, putting your life insurance in an ILIT. So if you have a life insurance policy, if you're going to get one, ILIT, irrevocable life insurance trust, can do a great deal, not only from an asset protection point of view, but from a taxation point of view as well. Moving along to limited partnerships. Limited partnerships are the most protective entity you can have in the entire United States. And if you're looking for a way to protect any liquid assets, checking, savings, stocks, bonds, brokerage accounts, the limited partnership is the way to do it. The way the limited partnership works, I kind of like to think about it like a house. So you have the square on the bottom for the foundation, the triangle on the top for the roof. And those are the two partners. The triangle on top for the roof is partner one. The square on the bottom for the foundation is partner number two. Partner number one is called a general partner, and partner number two is called a limited partner. Partner number one, the general partner, always owns the minority. Might be 1, 2, 3, 4, 5, plus or minus percent. Partner number two, the limited partner, always owns the majority. Might be 90, 95, 98, 99, plus or minus percent. And the interesting thing to understand is that although partner number one, the general partner, owns the minority, partner number two, the limited partner, owns the majority, partner number one, which is the general partner owning the minority, and only partner number one get to make the decisions. So some people think it's strange because you can own 99% of a limited partnership as a limited partner and you can't make any decisions. The person who owns the 1% of the general partner interest of the limited partnership makes all the decisions. So just something to understand. Well, what you do is if you have a checking, savings, stock, bond, brokerage account, and it's titled to your personal name now, you can lose it because it's exposed wealth. So what you do is you set up the limited partnership and you transfer your accounts, whether it's brokerage or cash or whatever it is, into the name of the limited partnership. Nothing else changes. You retain full control because the general partner is the one that makes all the decisions. So certainly, you would want to be the general partner, or from a more protection standpoint, we could create a company or a new entity to be the general partner that you own or control. But the point is with a limited partnership, you still retain all control. It's also income tax neutral. So you're not going to pay any more in taxes. You're not going to pay any less in taxes. Let's say you have $500,000 in your personal name and you make $100,000. Well, you're going to pay taxes on the $100,000. No different where if you have $500,000 in your limited partnership and you make $100,000, it's all flow through. It's all passed through right to your personal return. You're going to pay the taxes on the gain. There's potential estate tax discounts. So again, depending on what you have when you pass away, what the estate tax rules and exemptions are when you die, the limited partnership can also give you a estate tax discount. There's very strong creditor protection. They're inexpensive to set up and maintain, and they offer various flexible structure options. But the key to understand here is that if you have your liquid assets in a personal account with your name or you and your wife, you could lose everything. By taking those liquid assets and putting them in the limited partnership, you've totally protected them. No tax disadvantages, only potential tax advantages from an estate planning point of view. You still have full access to the funds. You can still bank where you want to bank. You can still invest in anything you want to invest in. You can still use any financial advisor you want. So nothing changes except you really wrap this layer of protection around you. And the really great thing about the limited partnership is that if someone sues you, they can't take the money in the limited partnership. The only thing they can do if they sue you is get what's called a charging order against you. And all the charging order does is gives the creditor distribution of profits due the debtor partner. So essentially all that means is that if somebody sues you now and your money's in your personal name, they could take it. If somebody sues you and your money's in your limited partnership, they can't touch it. The only thing a creditor can do is get this charging order against you. And what the charging order says is that if a distribution is taken from the limited partnership to you, well, then of course the creditor can take the money because then it's just unprotected money in your personal name. But if you remember back to the limited partnership, who the decision maker was, it was the general partner, which is you or a company that you own and control. So obviously you're never going to make a distribution if you have a creditor. So the creditor never ends up getting paid. No worries, you still have access to your money. There's other ways to get your money besides a distribution. You could take it out as a loan, a salary, a wage. You could send it to another company and pay your bills from there. So essentially the creditor is stopped from getting any money. Also, the creditor can't vote, inspect the books, assert other partnership rights. It's very limited on what a creditor with a charging order can do. And I would also argue, and this is the really neat part, that a creditor will pay taxes on the debtor's partner's pass-through income even if it's not received. So let's say the creditor gets a charging order against you for $500,000. We know he's never going to get it because the general partner, which is you or the company that you own and control, is never going to make the distribution. Well, if that creditor is entitled to $500,000, I would argue he's entitled to pay the taxes on the $500,000 he'll never see. Pretty neat. It's called phantom income. Creditors of a partner are limited to a charging order. Moving along to LLCs or limited liability companies, essentially they're a newer type of entity. People think they've been around forever, but really they've only been around for 30 or 40 years. They're kind of like a hybrid between the corporation and the limited partnership. The members' creditors are usually and sometimes limited to the charging order, but not always. And the manager and members' liability is obviously limited. No estate tax discounts. You can choose to have it taxed as a partnership or a corporation. They're less proven than the limited partnership because they haven't been around as long. And also not every business or profession can use the LLC. So there's different things that are great to use the limited partnership for and different things that are great to use the LLC for. The limited partnership is used for safe assets, call it cash, checking, savings, stock, bonds, brokerage accounts, and they're used for potential estate tax discounts. The LLC, on the other hand, are used for dangerous assets or business activity. So if you have checking, savings, stock, bonds, brokerage accounts, they're going in the limited partnership. If you have a business, it's going in an LLC. A boat, a plane, it's going in the LLC. Real estate, it's going in the LLC. And you can combine the limited partnerships in the LLC. And if you see from the diagram, on top we have the limited partnership, which would own all the liquid assets, and then it might own the shares of stock in a C Corp and the membership interest in the LLC. So it acts as a second layer of protection. Layer number one is you can't touch my business, you can't touch my boat, you can't touch my plane or my real estate because I don't own it. It's owned by an LLC or a C Corp. And layer number two is I don't even own the shares in the C Corp or the membership interest in the LLC. It's owned by the limited partnership. So not only can you protect the different assets with these different entities, but you can use them amongst each other to layer your protection and add more protection. I want to touch briefly just on international asset protection. We go outside the United States when U.S. protection is simply not enough. And, this is for someone who has, larger liquid assets. Certainly if someone only has a couple $100,000, doesn't make sense. But if someone has, $500,000, $600,000, $700,000, $800,000, at that point, it might be worth investigating. And essentially, it makes it so difficult and expensive, if not impossible, for anybody to collect against you that they don't want to sue you. If you had a proper international entity set up, first somebody would have to sue you in the United States and win. Then they would need to know the right questions to ask. Then they would have to go to the jurisdiction. Let's say you had a international trust set up in the Cook Islands. They'd have to fly to the Cook Islands. Last time I checked, there was one flight that left on Sunday nights, and it was from California. It was a 14-hour flight, so you're stuck there for a week. Then they need to hire a Cook Islands attorney, which may or may not be conflicted off the case because they work with attorneys like myself and the big trust companies. And then the creditor might have to go to New Zealand 6, 7, 8 hours away to find an attorney. They don't work on a contingency fee, so now you're paying your U.S. attorney hourly and your New Zealand attorney hourly to fly back and forth. There's a very short statute of limitations, so while, depending on what state you're in, if there's a car accident, you might have 4 years to sue in the countries we use, and I'm just using the Cook Islands as an example. There's better places, but there was a big Wall Street Journal article on it. You only have 0 to 2 years to sue. You might have to post a bond. If somebody's trying to go against a Belize LLC, you have to post half the amount. So if you're suing for $5 million, they have to post $2.5 million just to have the privilege of suing. There's no punitive damages. The amount of proof you need in the U.S. is 51% of the evidence. There it's beyond a reasonable doubt, 99.9%. And any good international entity has what's called a Cuba or a flee clause, which means you can relocate the assets at any time. So very difficult, very expensive, if not impossible for anybody to challenge. I think last time I checked, the stats were about 1% of all of the international entities are challenged, not beaten, challenged. And I apologize, I'm going quick just because, we are on a time limit. Don't go outside the United States to save in taxes. Everything's tax neutral no matter what you do. You can put all your plans together, so you might take your unprotected cash and put it in the limited partnership. The limited partnership might be owned by an international entity, et cetera, et cetera. So really this just deals with the layering of protection. I just want to touch very, very briefly on business succession planning. All this is estate planning for your business. And if you have a partner or partners, this is so important. Everything's fine and dandy while everybody's alive, but God forbid one of the partners dies, what happens? Partner number one dies. Partner number two, after partner number one dies, goes to partner number one's widow with a check for $500,000 and says, here's $500,000 for your half of the business. Well, what do you think the widow says? The widow says, you know what? It's not worth $500,000. It's worth $5 million. So they spend the next 3, 4, 5, 6 years battling out in court. They're spending hundreds and hundreds of thousands of dollars in legal fees. Meanwhile, the opportunity cost, the business is going down the tubes. So please, if you have partners in the business, you got to investigate business succession planning. I always like to end on a light note, and I would really, really encourage you to stay on because we are going to do a few Q&A, question and answers briefly. So I put together the 10 craziest lawsuits for you. Number one, a couple sued an airline over a cockroach sighting. The couple stated that seeing cockroaches crawling out of air vents caused them great distress and forced them to throw away their luggage in fear of cockroach contamination. Number two, a Michigan woman sued a studio for not accurately portraying a movie in their trailers. She claimed it lacked fast and furious driving action as depicted in the movie trailer. I love this one. A fugitive sued his hostages for not helping him escape. He claimed they promised to help him escape, and when they didn't, they breached an oral contract. A woman obtained walking directions which sent her down a highway. She followed the directions by walking in the middle of the highway and got hit by a car. She sued for bad directions. An employee sued for wrongful termination. The employee alleged that the company fired them because they helped customers during their lunch break instead of actually taking a break. I love this one. A wedding couple sued a photographer for wedding photos that didn't come out right. $4,000 as a refund, $48,000 to restage the entire wedding. A customer sued for being overcharged for sausage by 2 cents and won. 2 children sued their mom for not spoiling them. This is for any parents out there. The children claimed that she was a bad mom by requesting them be home by midnight, haggling over dress budgets, and failing to send them college care packages. They sued their mom for $50,000. A woman sued a police department for allegedly making her listen to Rush Limbaugh's radio show while she was handcuffed in the officer's car during the arrest. And finally, a man divorced and sued his wife and won $120,000 because she had an ugly baby. She had claimed that she was naturally beautiful, but she really had a lot of different plastic surgeries, so it was fraud. I know we went really quick today, guys, because we had very limited time. Certainly, if I didn't cover something that you wanted to, feel free to contact me. I'm happy to speak to you and have a complimentary preliminary consultation. I speak to Vistage groups nationwide, so if you liked what you heard today, tell your chair. I'm happy to come speak to your group. You know, I'm a Vistage member as well. And if you stick around now, we're going to do a couple different Q&A and question and answers, and I appreciate your time today, and I really hope it was educational and timely. And, you know, we all work so hard to make a living, but unfortunately, one act can take it all away. And, you know, we don't want to be retired backing out of the driveway and hit a bicyclist and lose everything. You know, we don't want to save up and have a couple different investment or real estate properties. You know, the renter, you know, slips and falls and we lose everything. So please, for every 60 minutes you spend making money, spend 60 seconds thinking about how to protect it. Again, thank you for having me, and I think now we're going to have a Q&A section.
That's right, Hillel, and we want to thank you for your time and your expertise. Well, the first question is, are certain jurisdictions better than others for international asset protection trusts?
You know, they are, and it's not even just for international or domestic. If you use the word international trusts, I would say no, because I don't think you don't want to do any domestic asset protection trusts. But if you're talking specifically about an international trust or a domestic protective entity, jurisdictions change, and there's always about a half a dozen jurisdictions that are good. You know, you always hear about them: Wyoming, Nevada, Delaware, Alaska, Florida, et cetera, et cetera. And each year they could fight with each other to have the better laws, because if you think about it, whoever has the better laws, well, they're going to get more business registrations, which means that they're going to make more money. So while today, you know, there might be 3, 4, 5, 6 good domestic jurisdictions, 3, 4, 5, 6 good international jurisdictions, always just keep in mind that it's changing on a yearly basis. You know, I just worked and helped to rewrite the Nevis international laws. So while that might have been second or third best, we might see that being first best. So again, just understand that things do change, but there's always about 3, 4, 5 good domestic and international jurisdictions, and everything's individualized and customized and tailored, and you just need to find the right fit for you.
Sounds good. Well, who may be listed as the agent for service of process?
Okay, so anytime you have a company, there must be what's called a registered agent, which means somebody who can accept service of process in case you're sued. And it must be someone in the state. So if you're a client in Florida and you set up a Florida entity, you can choose to be your own registered agent. If you don't want your name on the company, there's many corporate companies out there that will charge you $50, $100, $200 a year that will do it for you. That way you can remain anonymous. However, if you're a Florida client and you set up a Delaware entity, for example, you do need somebody in Delaware to act as the registered agent, so you would then hire a Delaware company, again, $50, $100, $200 a year, or you can use a Delaware attorney, or if you had a friend in Delaware, you can use them. But the short answer is it must be somebody who resides in the state of where the company is.
Okay. Next question is, you mentioned that revocable trusts are bad for asset protection, but are there some benefits to them?
Absolutely. Revocable trusts are great for estate planning. I think everyone should have one for estate planning. When you pass away, if you don't have a trust, everything will be public record, so everybody will know what you died with. Instead of taking a couple months for your assets to go where you want them to go, if you don't have a trust, it could take years. And instead of paying attorneys hourly, if you don't have a trust, the attorneys can take an actual percentage of your entire estate. So although a revocable trust won't do anything for you from an asset protection point of view, it'll keep your assets private when you die. It'll get your assets where you want them to go much, much quicker, and the legal fees will be much, much lower by having the trust.
Wow, that's really good to know. Okay, next question. How can a family limited partnership help me make discounted lifetime gifts?
So essentially what a lot of people do with the limited partnership, if you remember, the general partner makes the decisions, and the limited partner owns the majority. So what a lot of parents will do is over the years they will gift small amounts of the limited partnership interest, that's the non-voting interest, to their kids. So every year their kids are getting a small amount of this limited partnership non-voting interest. What that means is after 5, 10, 15, 20, 30 years, their kids might own the majority of the company, which the parents want because they want it out of their name so they don't pay the estate taxes. But because the parents have kept the general partner interest, which is the voting interest, they still control everything. So the limited partnership is a great way to transition assets out of the parent's name into the kid's name without losing control.
Well, we have time for one last question, and it's, when should I use an international trust over a domestic trust?
Well, again, just to reiterate, there's two different types of domestic trusts, the revocable trust and the irrevocable trust. You can use a domestic revocable trust anytime you want, as long as you understand it's only estate planning and you get no asset protection. There's no problem using an irrevocable domestic trust if it's set up correctly, although, again, most people don't want to do it because they don't want to irrevocably give away all of their assets. So the international trust is really, really a nice compromise. And I would say, again, there's no black and white number. If you have $500,000, $600,000, $700,000, $800,000 of liquid assets or more, you should become educated or at least investigate the international trust. It still might not be for you, but it's worth becoming educated on.
Well, Hillel, we want to thank you so much for being with us today. This is great information and very helpful. And next Friday, we have another interesting, helpful topic and a good speaker. It's about strategy. Execution is the strategy, how leaders achieve maximum results in minimum time. Our speaker is Laura Stack. I know her. I've heard her speak, and we'll get lots of practical advice as she tells us how we can be strategic with our priorities, our goals, and help our employees move through a more strategic culture. So be sure and join us next Friday, August 7th, at the usual time. Well, thank you all for being part of this Fridays with Vistage webinar. For Hillel and all the great people at Vistage, I'm Lori Allen. Have a terrific weekend.